Hi everybody, welcome to the first lesson for Legal Studies 3-4. In today's video, we're going to be going over the principles of justice, summary versus indictable offences, the burden and standard of proof, and the rights of the accused and rights of the victims. So to start off with, this is just a brief overview and good definition of each of the three principles of justice. It's really important to get a good grasp on these because they're going to come up again and again throughout Unit 3. And it's a good chunk of the exam linking all of the content you've learnt back to the principles of justice. So to start off with, fairness is impartial and just treatment without favouritism through court processes. So what that essentially means is that both parties are being treated the same, that there's no disadvantage presented to the accused, or there's no difference in the way that accused in different trials are treated. For example, it would be unfair for one accused in a case in 2020 to be considered innocent until proven guilty, whereas in a case in 2021, the accused was presumed guilty before being proven innocent. So there has to be court processes that ensure that parties are treated the same. So essentially, fairness is anything done by the court to ensure that parties aren't presented with an unfair advantage or disadvantage. So things that uphold that are rules of evidence and procedure, which outline the way that parties need to be treated. An impartial judge, because judges who aren't biased will ensure that those rules of evidence and procedure are applied in the same way to both parties. And also, as we said before, the presumption of innocence ensures that accused in different trials are treated the same. Next, moving on to equality. Equality is ensuring that individuals are treated without discrimination and prejudice due to a personal characteristic or attribute. So equality is about anything to do with nationality and ethnicity, religion, socioeconomic status, language barriers. And often with equality, parties will have to be treated differently in order for it to be equal. So in order for it to be equal, a party may be provided with Victorian legal aid to ensure that they're represented in the same way that the opposition is. And also maybe provided with interpreters if there's language barriers. So equality is different to fairness in the sense that it's something about that particular party that's meaning that they need to be treated differently in order to receive equal treatment before the law, whereas fairness is more about ensuring that the parties are treated exactly the same so that there's no unfair advantage. So anything you see, anytime you see anything about money or language or ethnicity or religion, that's going to be equality. Access is the opportunity to understand legal rights and pursue a case through legal institutions. So essentially anything that reduces costs and reduces time delays. Increases an individual's opportunity to make use of the court systems. And so access is usually the easiest one because most of the content that you learn does have the purpose of reducing costs and time involved. Moving on to summary offences. So summary offences are less serious offences, and this isn't super important to know, but sometimes they might give you a question with a case study, and they might ask you to identify whether it's a summary indictable offence. If it mentions that it's in the Summary Offences Act, then it would definitely be a summary offence. Summary offences are heard in the magistrate's court by only a single magistrate, so there's no jury involved. Summary offences are beneficial because it receives a maximum term of imprisonment for one offence or 5 years for multiple offences. Another indication in a case study that it's a summary offence and not a indictable offence would be that they refer to it as a hearing. We don't really technically refer to summary offences or trials or cases heard in the magistrate's court as trials. Indictable offences usually are called trials, whereas summary offences are called hearings. Some examples of summary offences include traffic offences, shoplifting, minor assaults. Indictable offences are then your more serious criminal offences, and as we said before, we refer to them as trials, not hearings. Some examples would be rape, murder, drug trafficking, terrorism. And Another way to identify them, if given in a case study, would be if they say that they're outlined in the Crimes Act, which is where only indictable offences are outlined. Indictable offences are heard in the county or Supreme Court and heard by a judge and a jury. As we'll learn later on, the accused has a right to a trial by jury for all indictable offences. And unlike the summary offences, there's an unlimited range of sanctions for indictable offences. So depending on the type of charge that the accused is accused of, there is a range of sanctions outlined by that Act of Parliament, and the judge has to decide where in the range of sanctions that case sits. So for murder, it might be 6 months to life. And then the judge needs to work out what would be an appropriate sanction within that range for the individual. The next thing to note is indictable offences heard summarily. So this is where the accused has the choice to have the case heard as either indictable or summary. This is only given to accused where the maximum term of imprisonment is 20 years, so not very serious indictable offences, or a fine of up to $120,000. The reasons why somebody would choose to have their case heard in the magistrate's court is, as we said before, there's less risks of sanctions. There's only 2 years for one offence or 5 years for multiple offences. There's also a lot less costs and time delays, so which is beneficial to a party, especially if they're being held in remand and that kind of thing. And there's also no jury fees. The reasons why somebody may choose to have it in the county or Supreme Court and have it heard as an indictable offence is the fact that there's trial by jury. And so a jury is more likely to acquit than not, especially when there's more of like a human kind of personal side to a case where the jury will connect to the accused emotionally. Next, moving on to some of the introductory points of criminal law, we have the mens rea and the actus rea. So mens rea is the criminal intent. The prosecution has to prove that the accused had the intent of committing the crime for certain crimes such as murder. If there's no intent, then that goes down to manslaughter. Then the prosecution will also need to prove that the accused actually committed the criminal act, the actus rea. So there's 2 elements of a crime, and the prosecution will try to prove both. If they can't prove the mens rea, then they can get away with just proving the actus rea. The prosecution also has to discharge the burden and standard of proof. The burden of proof comes first. That's the responsibility of the party initiating the case to prove the facts and prove the claims that they're making. And so because in this case, it's the prosecution who initiates the case, it's the prosecution who has to prove all evidence and all claims against the accused. The standard of proof is the quality of the evidence that the prosecution has to present in order to prove the case. And for criminal law, that's beyond reasonable doubt. So if the jury has any doubt, then they must acquit the accused. So it's a very, very high threshold. And the reason for that is because in criminal law, there's a lot of ramifications if the accused is found guilty. You know, they can be sent to jail, have their civil liberties curtailed. And so there's a very high threshold for the prosecution to meet. The final thing to note is the presumption of innocence, essentially that the accused is presumed innocent of all allegations up until the point that the prosecution discharges the burden and standard of proof. Things that uphold the presumption of innocence in our criminal justice system is the opportunity for bail, also the right to silence. The accused doesn't need to self-incriminate themselves, and silence cannot be considered an admission of guilt. Also, the fact that the prosecution has to discharge the burden and standard of proof, that is upholding the presumption that the accused is innocent up until there's enough evidence to prove otherwise. Another thing is that prior convictions are not heard until sentencing, so that ensures that the jury's opinion is not affected by any prior convictions, and also the right to appeal. Now moving on to the right to the accused. So the first right is the right to a fair hearing. This ties back into the definition of fairness as one of the principles of justice. And remember that fairness is all about parties being treated the same and ensuring that the court doesn't present one party at a disadvantage or advantage due to the way the court treats them. The way that fairness and the right to fair hearing can be upheld is through having a competent and independent judge. So the reason that upholds fairness is because the judge is aware of all rules of evidence and procedure. They know how to run the case and ensure that the parties are treated fairly, and they will apply those rules equally to both parties. The impartial hearing, again, goes into the sense that there's no favoritism towards either parties, again, due to the judge's impartiality. Legal representation is upholding fairness because this ensures that the parties are aware of their rights and their rights can be properly advocated for in court to ensure that both parties are treated in the same way and that no party is being at a disadvantage because they aren't aware of their rights and therefore aren't able to uphold them. Another element of the right to a fair hearing is the public hearing. So we have open court. Anyone from the public or the media can come in and watch a criminal trial unless it's closed due to privacy reasons, usually for sexual offences or family offences. And so the public hearing ensures fairness because members of the community and the media can scrutinise the court and the judge if court processes are not upheld. And if there's any issue and a party is not treated fairly, then the media and the public can raise attention to that, and that situation can be remedied to ensure parties are treated fairly. This right is outlined in Section 24 of the Charter of Human Rights and Responsibilities Act, which is something extra that you can put in your writing. The next right of the accused is the right to trial by jury. So for all indictable offences, remember your more serious offences, the accused has the right to be trialled by a jury, which is 12 members of the electoral roll who are randomly selected. The point of having a trial by jury is to ensure that community values are considered, and it acts as a buffer zone between the judge and the accused to ensure that it's not just the decision isn't only coming from someone in a position of power, but the decision also reflects our community values and the community concerns. The jury also spreads the burden of decision making to eliminate any bias because rather than it being made by one individual, it's now being shared among 12. And they need to make either a majority verdict, 11 out of 12, or a unanimous verdict, 12 out of 12, in order for the accused to be found guilty. This right is outlined in Section 80 of the Australian Constitution for Commonwealth indictable offences and also outlined in the Criminal Procedure Act. The third right of the accused is the right to trial without any unreasonable delay. So a quick thing to mention is that delays are inevitable in the criminal justice system, especially now with the COVID pandemic. The backlog in courts is significant, and there are a number of court processes that need to be upheld prior to trial. So there's always going to be some delays. Usually it will take at least 12 months in order for a trial to run. However, the right to trial without unreasonable delay is talking about avoiding all unnecessary delays. So all parties and the court should be doing everything they can to reduce delays as much as possible. This ensures that both parties can prepare adequately and there's enough trial to ensure that there is enough evidence presented at trial and the actual trial reflects the facts of the crime. However, it ensures that the accused is not unfairly disadvantaged because they may be held in remand and also the costs increase as delays increase. Also because there's a lot of uncertainty and stress for the accused if there's unnecessary delays, and so they want to reduce that as much as possible. All criminal matters commence with a committal hearing 3 to 6 months after charging, and that is there to reduce delays as much as possible by setting a timeline for the first committal hearing to commence. We'll cover committal hearings in the next video, but essentially that's the first pre-trial procedure that the courts have to go through in order to prepare for trial. The right to trial without unreasonable delay is outlined in Section 21 and Section 25 of the Victorian Charter. Next, we move on to the rights of the victim. Victims are any person who has suffered an injury as a result of the accused actions and the crime, a family member of a person who has died of a criminal offence, a family member of a person who is under the age of 18 or is incapable of managing their own affairs because of a mental impairment, and a child who is under the age of 16 who has been groomed for sexual conduct and that child's family. So a lot of the time, the victim's rights don't only apply to the person who's been affected by the actual crime or the accused actions, but also their family as well. The first right of the victim is the right to give evidence as a vulnerable witness. This is for victims of sexual or family offences or victims of violent, obscene, indecent behaviour by the accused. The purpose of the right to give evidence as a vulnerable witness is to ensure that the victim is comfortable when presenting evidence and are not intimidated, to ensure that the evidence that they provide is as accurate as possible. This is upheld through the alternative arrangements that are provided to victims of such offences. So victims can be provided with the opportunity to give evidence via CCTV from another courtroom, to use screens to obstruct their line of vision to the accused, and they can have support people beside them when giving evidence. This is all to reduce the amount of contact between the accused and the victim of sexual and family offences, so that the victim does not feel re-victimised or threatened when giving evidence. Another thing that the court can do is declare a victim a protected witness, which ensures that they cannot be cross-examined by the accused. So it would be unfair for a victim of a sexual offence to be cross-examined and questioned in court by the attacker. So in that case, they have to have legal representation, and if they are self-represented, then they must be provided with Victorian legal aid to ensure that the victim is not being cross-examined by the accused. Another element of this right is that under Section 41 of the Evidence Act, the court can have more power in reducing the types of questions that are presented to victims of sexual and family offences. So the defence cannot ask the victim any humiliating, intimidating, or repetitive questions which would threaten the accuracy of their testimony. The next right is the right to be informed about proceedings. This is where the prosecution has to give the victim all essential information regarding the trial. So they have to outline any bail applications made by the accused, any offences that they're actually charged with, the sanction and the length of the sanction that the accused receives, any reasons why the accused may be acquitted, any appeal applications, and also outline when the victim is required to give evidence at court. This is because victims may not always want to be in attendance at court because it is very stressful and it can cause a lot of mental harm for the victims of some offences. And so if they wish not to attend court or they're unable to attend court, the prosecution has to provide them with all essential information so that they're still involved in some way. And the final right of the victim is the right to be informed of the likely release date of the accused. So for victims of offences where the accused is sent to prison, the victim is able to be on the victim's charter, and they are able to be kept up to date about the accused's likely release date of from prison. And so when that time comes and the accused is eligible for parole, the victim can make submissions to the Adult Parole Board to prevent the accused release. And also it ensures that the victim is aware of their release so that they can make arrangements in their own lifestyle to prepare for that change. That brings us to the end of video 1. In the second lesson, we're going to be covering CLCs, Victorian legal aid, committal proceedings, plea negotiations, and sentence indications, which is probably the most in-depth part of this area study. So I hope to see you there.